A couple walks into mediation. They've been fighting over the house for 8 months. She wants to keep it for the kids. He says he cannot afford to walk away from the equity. Their attorneys are billing. Their kids are watching, and they're stuck. Their mediator asks one question. If we set the house aside for a moment, what does each of you actually need to feel stable over the next 3 years? She says, I need the kids to stay in their school district. I need them to feel like their world is not falling apart. He says, I need to know I can afford a decent place nearby and still retire someday. Within 2 hours, they designed an agreement a judge would never have ordered. She stays in the house for 3 years until the youngest finishes middle school. He gets a larger share of retirement assets to offset the deferred equity. They split the proceeds when the house sells with the formula they both helped write. And they build in an annual check-in to make sure things are still working. That is not a compromise. That is a design. That is what mediation can do when people stop arguing over positions and start building towards interests. Today, we're going to go deep on how mediation creates room for creative, customized, human-centered solutions that courtrooms simply cannot provide. And I have brought in one of the best family law attorneys I know of to talk about it. Welcome to the Conscious Divorce Podcast. I'm Justin Milrad, certified divorce coach, author of U 2.0, Transform Your Life After Divorce, and founder of Reclaim and Reboot Transformational Coaching. This podcast exists because I believe divorce does not have to destroy your life. It doesn't have to drain your bank account, wreck your mental health, or damage your children. There is a better path, and it starts with being strategic, intentional, and conscious about the choices you make during one of the most consequential transitions in your life. Whether you're thinking about divorce, going through it right now, or trying to rebuild on the other side, this is a show that gives you the frameworks, the tools, and the honest conversation to help you move forward with clarity and purpose. Today's episode is one I've been wanting to do for a long time. We're talking about mediation, but not in the generic surface level way you've probably heard before. We're going to go deep into creative solutions that mediation makes possible, the kind of agreements that actually work in real life, the kinds of outcomes that a judge sitting on the bench with 100 cases on the docket simply does not have the time for or the information to design. But before we jump in, I want to say something I say at the top of every episode because it matters. I'm not an attorney. I'm not a therapist. I'm not a financial advisor. I'm a certified divorce coach, and everything we discuss on this show is for educational and informational purposes only. It's not legal advice, financial advice, or clinical advice. My guest today is Rebecca Miller, who is a licensed attorney in the state of Nevada, and her comments reflect decades of general experience in family law and mediation. But nothing she says today constitutes specific legal counsel for your situation. If you're going through a divorce, get your own qualified attorney, get your own financial professionals, get your own therapist, build your team. That is actually one of the things we're going to talk about today, how all those professionals can work together in mediation to get you a better outcome, one that you can live with and be good with. All right, with that said, let's get into it. My guest today is someone who has spent nearly 4 decades in family law, which is remarkable in and of itself. She has seen everything. Rebecca Miller is an attorney with Cooper Coons in Las Vegas, Nevada, where she heads their family law department. She's been practicing family law since 1987. She has served on the executive council of the family law section of the Nevada State Bar for 8 years. She sat on the disciplinary panel of the State Bar of Nevada for 9 years. She's a trained collaborative divorce law practitioner, and there are only about 25 attorneys in the entire state of Nevada with that training. She is also very much focused on amicable divorce, which she will talk about a little later. She works in domestic relations and mediation. She's an active arbitrator and mediator, and she earned the American Jurisprudence Award in Family Law and the Los Angeles County Bar Family Law Scholarship at Pepperdine University. She literally got the highest grades in her family law class. But here's what I love most about Rebecca. She grew up in a close-knit family in Las Vegas, working in her parents' dry cleaning business, where she learned people skills and business sense before she ever set foot in a courtroom. That combination of real-world empathy and legal expertise is exactly what makes her perspective so valuable. Rebecca, welcome to the Conscious Divorce Podcast.
Thank you, Justin. I'm so happy to be here and get the word out about mediation. It's actually catching on pretty well in Vegas, but could be better.
Fantastic. Well, Rebecca, you've been doing this for almost 40 years. You've seen litigation, mediation, arbitration, collaborative divorce. When someone asks you why mediation matters, what do you tell them?
Well, I tell them it is a unique way of having some control when people are getting divorced, and I am divorced myself. When your spouse tells you, I'm done, or whatever they say, and whatever they do to leave the house, you're shocked, you're hurt, you're angry, and you're worried. You don't know what's going to happen with your life, your assets, if you have children, and you're worried about, ooh, what's a judge going to be like on my case, and what's the law. You don't know any of these, and the unknown is very fearful.
Absolutely.
So me
Love everything
uh,
you said. And something similar that I say to my coaching clients is that courts give you a ruling, whereas mediation gives you a design table. And the difference between those two things is enormous when you're trying to build a life that actually works on both sides. People hear the word mediation and they think it means compromise. They think it means splitting everything 50-50 and no one gets what they want. But that's not really what it is. Can you tell us a little more about what real mediation looks like and what effective mediation looks like?
So the audience knows I am a mediator where I sit down with the couple and email and phone calls without attorneys. I also mediate when attorneys hire me and they've done the discovery, they've got expert witnesses, they have reports, they send everything to me to read, and then they come meet with me, or sometimes I go to their office, and I've got two attorneys and a husband and a wife. Or wife and a wife lately, husband and husband, doesn't matter, sometimes a non-marriage, and they've co-owned things, property, and they have children together. So those are the types of mediations I do, and what it does is it gives people a voice. They have a say. Nevada is a community property state. We start with the presumption that everything is 50-50, but a lot of times it does not end up that way. I can trade assets, trade debts, trade things for alimony, which we can talk about later. You have the mediator and the parties work together. It's their life, it's their case, and I'm here to listen, figure out what each one wants, and try to give it to them, try to suggest it to them.
So, are you supposed to be impartial?
Absolutely. I tell them that 100 times. One of them will usually call me or email me. I will call that spouse. I will give them the option. I definitely check for domestic violence, any mental issues. I ask about drugs, alcohol. I want to make sure before they hire me to mediate that they are the proper party, so to speak, to mediate, that someone's not going to walk out halfway through or even at the beginning, or I've had somebody end it at the end because she wanted more and ended up in trial. And when they walk out, I can't represent either one of them. Then I call the other one and I say the same thing. I explain I am neutral, I don't take sides, and I explain that obviously it may not be for them. I ask questions, and before I know it, both of them are agreeable, or I have a new one right now. The husband told the wife, find a mediator, and then have her call me. So I called the wife first because she called me, called the husband, and they're on board, ready to go.
Fantastic. So, the next question is really one that I know every listener is thinking. Where do people usually get stuck in mediation, and what are the landmines?
Well, if they have children, that's usually the first thing. They know their children might have two homes. Sometimes one of the spouses is sleeping on his brother's couch. I have all kinds of situations. Some have a new apartment. Some are living with a new boyfriend or girlfriend. So the children, what's going to happen with them? How are they going to feel? What's the parenting plan going to look like? That's a big fear. In Nevada, the second fear is the house. We have such a strange housing market. It goes from during COVID, houses were selling like crazy. I had one that sold $50,000 over asking price. Then it settled down. Then it went back up. Now it's not too bad. I had a realtor just sell one for top dollar. So you only need one buyer, but people move around. People come from California, different states with cash, which is good, but somebody wants to keep the house usually, and we have to come up with unique ideas on how to do that. So I'd say children and house, and the next thing is money, of course, the financial accounts, whether someone's gonna pay alimony, whether someone needs it.
Sure. That's a big one. What about business ownership, emotional wounds, things like that? Do those come up frequently?
Yes, if somebody has a business, of course, the business owner wants to keep it. Judges rarely hear order how a business sold. Sometimes I'm in the process of doing a divorce where they've already decided to sell the business. I represent a lot of people in their 50s and 60s, even as old as 70s, and they're thinking about retirement, or maybe they've had a good offer and there's some money there. We hire a business evaluator and we go from there. But a lot of times the person working, I usually tell it is still a little one-sided here. Men still make more than women. So my alimony cases are men paying the women. Had it the other way, have no most of the time it's actually no alimony. Women have good jobs in Vegas. And our cost of living's gone way up, but it's still less than most states. So yes, the business can be a real thorn in someone's side to figure out what do we do.
Yeah. And then the emotional part, that's always such a roller coaster and unpredictable. I want to underline something that you touched on because it's one of the most important things that I teach my clients. It's almost never about the thing you think it's about. It's not about the couch, it's not about the holiday schedule, it's not about the extra couple $100 a month in support. It's often about
Mm.
fear, it's about control, it's about betrayal, it's about feeling unseen. And until you name the real issues underneath the legal issue, you're going to keep spinning. I tell my clients this all the time. The person who can separate the emotional injury from the legal negotiation is the person who gets the better outcome. Not because they stop feeling, but because they stop letting their feelings drive their strategy.
Mm.
Rebecca, one of the foundational concepts in mediation is the difference between a position and an interest. Can you walk our listeners through that? Because I think a lot of people don't realize they're arguing about the wrong thing.
And sometimes they're saying the same thing, but they're so angry or depressed about the divorce. I see this when the attorneys bring their clients. I start out in the same room, big conference room, and I've read everything. And I start talking about the easier things, like maybe everybody's going to keep their own bank account, the car. Nobody fights over cars. Maybe a value if something's paid off, but not usually. The furniture. And sometimes they start arguing. I'm looking at them thinking, you just said the same thing as you agree. And I point that out. And once you get them in that agree mode, then it moves forward pretty well. And I also, when I represent people that don't have attorneys, it's just the three of us, I talk to them separately because I try to explain. I can always tell there's always one who doesn't want the divorce usually. I've had some where they both want it, but there's always someone that's a little bit more fearful, hurt, wants an apology, feels that they're not being heard. So I try to make them understand they will be heard and we will try that together, but I can talk to them separately. I can email them separately and I can assist them separately and let them know that yes, no one's getting one up on the other. I don't allow that to happen because my private mediation, most of the times they don't hire an attorney to look at my paperwork. I do all the paperwork afterwards. And I tell them so much. That's the whole idea, to save money and time and effort. But yeah, they need to know that this is a business deal also when it comes to assets and money. But it's a emotional situation. What do we do what's best for the children? And I pass along what I've learned from therapists, which help them because they aren't in therapy most of the time and they need to go, which I do tell them they need to go.
No, absolutely. So I want to remind everyone of the concepts, the definitions. So the key concept, a position is what someone demands, an interest is the need underneath it. So there are multiple paths that can serve an interest, and only one path can serve a rigid position. And that's one of the most powerful reframes in all of divorce strategy. And I think it applies way beyond mediation. It applies to co parenting conversations, it applies to how you communicate with your attorney, it applies to how you think about your own future. When you stop demanding a specific outcome and start getting clear about what you actually need, you open up possibilities you couldn't see before. Let me give the listeners a framework for this because you walk into any negotiation, mediation setting, or even a co parenting conversation, you got to ask yourself three questions. What am I asking for? Why am I asking for it? And is there another way to get that thing I actually need? And if you can answer these three questions honestly, you are already ahead of 90% of people going through divorce. So, one thing I would love your opinion on is preparation. And what I notice often with my clients is they're not really prepared for mediation. They don't know what the numbers they're looking for should be. Uh, and that's a big issue. And I think that's where someone like a divorce coach or a financial planner can really help. People go into mediation saying, well, I want the maximum I can get, but maybe that's not what you need. And maybe if there's another number that can make this happen, so you don't have to go to court and spend all that time and energy and money, you can get there. So I'm kind of curious, in your opinion, what does good preparation look like? And also, why are many people not truly prepared for mediation?
The ones that come with their attorneys obviously are prepared. There's been discovery, everybody's seen every statement on every asset and debt, and they've discussed a parenting plan. A lot of times they've had the child issues settled and resolved before they talk to me. But sometimes those attorneys start taking a position because they're attorneys. They like to do that. That's not necessarily good for the client. Or sometimes tax issues. I'm not a CPA. I don't give tax advice, but I've been doing this for so long that I've had to learn and take seminars on taxes and understand how that connects. And sometimes I find that all four of them come and they have no idea they're talking about cashing out an IRA. I have to say, "Okay, warning, here's what I've heard from my CPA that I work with or my financial planner, but go talk to them." But we need to look at that and maybe not go that way. So, the ones that come without attorneys, which is most of my mediations, I don't make the first session the end all be all. It's to meet, we talk about the parenting plan they've already seen that I've sent them. I ask them to talk about it and meet. It's their family, not mine. And then we sit and talk about the issues that maybe they can't agree to. And again, I listen a lot. I talk less and I listen a lot so that maybe I can figure out what do they each, like you said, need, not necessarily what they want. And I come up with ideas. Of course, the court has all these customs, so to speak. They're not laws. For instance, first right of refusal, where you call the other parent to babysit on your time. That's in Nevada, that's not a law, but it's something the court does. So there's a lot of little tricks in parenting plans that they have no idea about. So that's what I focus on. And if we have to meet again, we do. And then a lot of times we do a lot by phone and email or conference calls. So that's how I handle.
Okay. Let's talk about parenting schedules and creative solutions. I remember the first time you and I spoke, we talked about one of the keys to being successful in mediation is coming up with creative solutions, something that is a lot harder to do when you go to court. So let us start with parenting schedules because this is where most of the emotion lives. What sort of creative scheduling solutions have you seen in mediation that a judge probably would have never offered?
Well, the first thing I do is find out what do they do for a living. As you know, in Nevada, it's a 24-hour town, so I could have casino workers that start work at midnight, 3 a.m. I actually have a police officer now that starts at 10 p.m. And what are their days off? And they don't realize that matters. Sometimes they come to me and tell me, "Well, I want this day and this time," and I have to ask, "Are you home? Are you available?"
Yeah. Are you awake?
So yes, you're right. Yeah, a judge is not going to sit and look at that. They're gonna say, "Okay, here's your half of the week, and here's your half of the week." Nevada is joint legal, joint physical. Again, presumption, we start that way. I've learned from therapists, smaller children, younger children need to see a parent every 2.5, 3 days. When you get to middle school, especially high school, these kids do not want to transfer homes twice a week. So I
Mhm.
look at ages, I look at their lifestyles, I look at their incomes, I look at where they're living. If somebody's on a couch, a lot of times they'll say, "Yeah, I can't have the kids overnight, but here's what I want." So that's something that I formulate for them. Or sometimes they keep the house and they have an apartment and they call that bird nesting, I guess, where the parent switches homes and the children stay in the same home. I don't know that I've seen that that's realistic, especially in Nevada. It seems like the person who's wanting to leave really wants to leave and have their own place. But the judges have been good about one thing. If you leave and you have only, let's say, a one-bedroom apartment, you're still gonna get your child. You're gonna figure it out. If she's an older girl, she's gonna get the bedroom and you, mom or dad's gonna sleep on the couch, or you're gonna share the room, depending on the age, on the sex of the child. So, again, just listening and learning their lifestyle and figuring out what can we do to maximize the time and the holidays and vacations. Some people tell me, "I don't get vacations or I work holidays." So I have to come up with, okay, when else can they have their child? So it's
Right.
case by case.
One of the things that I want to make sure we talk about is that the best parenting plans are not static documents. They're a living framework that evolves as your children grow. A schedule that works for a 4-year-old is not necessarily going to work for a 14-year-old. And if in your agreement, you can add a mechanism for revisiting on a periodic basis, you're going to save a lot of time and frustration, money, and hopefully not end up back in court. One of the things I do with my coaching clients is I help them build in a parenting plan review. Some of them sit down once a year for a period of time, and then they extend the time frame. Possibly they work with a mediator or a parenting coordinator, and they ask the question, is this still working? What needs to change? And having this one clause in your parenting plan can really make a huge difference. What about holiday schedules? Because that's another place where people dig in hard.
Yeah, again, in Nevada, we pretty much look at summer as the vacation time. I try to alternate. Spring break here is a whole week. It used to be the week after Easter. They don't want to wait for Easter because Easter keeps changing and it could be as late as the third week of April. So they've set it around the third, fourth week, depending on which level of education you're in, of March. And then we've got Christmas. They get about 2 weeks off, and Thanksgiving they keep going from the whole week off, and then they go back to Wednesday afternoon after school, and then they go back to school Monday. Right now, that's what it's at. So I, again, listen to schedules. Hopefully, if nobody has to work on the weekend, I try to alternate spring break and Thanksgiving. Most people don't want to share a holiday. They don't want to split the day in half. Again, if the child's younger, you do that. And like you said, when they're maybe 8, 9, 10, we change it. When they're teenagers, we might change it again. So I always tell them, look at the calendar. If you've got spring and break in even numbered years, that's a whole nother week of vacation you have, not just maybe the 2 or 3 or 4 weeks you agree to in the summer. Plan ahead. Tell your boss you want that week off, and now you've got an extra vacation. And they look at me like I came from Mars and wow, where did I come up with that idea? So it's kind of fun. And then I usually try to just split. There's what, a 48-hour period between Christmas Eve and the 20th, and exchanging on Christmas Day. Again, little kids, you want to see your kid that day. The older kids, sometimes we just switch on the 26th. Each party gets a week. Some people need to travel to go see grandma and grandpa. It is so tailored to what the parties need and want. And I love that because if you go to court and argue, each department now has this horrible. I don't even know who created it. It means nothing about who gets what. It's like mom gets these dates odd years and dad gets these even years. And and I warn the clients, they don't work this out with me. That they're going to go to this mediation at the courthouse. It's not, in my opinion, as good as you and I working with a client, and or the judge is going to hand them in court this typed version that has nothing to do with their children or their life. Yeah, that's why mediation, another reason is stay out of court and this is your family, work on it.
I think that's where flexibility is really important. That's where you really need to invest in co parenting because things change. One of my
Yeah,
favorite examples is you have 3 kids at 3 different schools and they have three
yeah,
different spring breaks. So what do you do in that case? If you're employed, you only get so many weeks of vacation. So it's a great opportunity to work with the other co-parent, and maybe in some years you take 2 of the kids and they take one and vice versa, and the kids get lots of exposure to their parents. The flexibility is really, really important. I'm kind of curious on the main decision making categories: education, medical care, religious upbringing, and extracurricular activities. Is this an area in mediation that parents typically agree on and do what's best for the kids? Or is this an area that you find there's a lot of contention?
Most of the time, there's not contention. Again, we're a joint legal state, which my parenting plan has, I think, 3 pages of what joint legal means, and it's broken into paragraphs, and one will talk about the choice for schools, one will talk about religion, school records, medical records, choice of doctor. I pretty much don't give them a choice. I tell them this is what the judges expect, no matter who has physical custody, and you are to talk to each other and share. Possibly use a parenting app or program where you email each other constantly just about the children, nothing else. And you send reports in there, and you can put in the whole, once I do the parenting plan, you can put in the whole holiday schedule and vacation schedule and weekly timeshare and see what it looks like. And that's why I said, look ahead and decide, hey, we're going to take a vacation. It's my spring break. And I tell them, you don't need the other party's permission if it's your time, but we have rules about itineraries, notice, leaving the country, depending on which country you're going to. Some countries are considered dangerous and a no-no. I've actually gone to court about that. Somebody wanted to take the
Right.
children to Egypt. There was a big
Yeah.
war. So, yeah,
Listen,
that's how,
fair.
so it's not a huge area of contention, and sometimes one parent is a little more in charge just because they take charge and they do all that, or if mom's been a stay-at-home mom, she just continues to do that, let dad know, and a lot of times the father's fine with it. So, yeah, thank God that's not a huge area here, at least.
Right. Realistically, the people who are fighting over this stuff will likely end up in court anyway. They're
Right.
not suited for a mediation. So there's one question that I'm kind of curious whether or not a mediator would answer. And that question is, if this were to go to court, how do you think a judge might rule? Is that a reasonable question?
Yeah, sometimes they ask me that, but sometimes when I see there's a little difficulty, somebody's not wanting to agree, or somebody's being a little stubborn about something that I think the judge is not gonna either listen to that or they're gonna rule opposite, I'm constantly saying, "We go to court, this is what the judge will likely do." I don't have a crystal ball, but I know all the judges. We have 26 family court judges in Las Vegas, and I know them all. Some are younger, my age, older, some are good, some are horrible. Uh, that's why I do this, and I warn them. And that seems to bring them back down to reality and from taking unreasonable positions.
Thank you for that. All right, let's move on to the house, the marital home. So
Okay.
you had mentioned earlier it's one of the possible sticking points, or it's a big item that needs to be negotiated. What are
Yeah.
some of the creative options that mediation opens up beyond just selling and splitting?
So I make sure, first of all, we either get realtor comps. Sometimes I use the online. I'll look at Redfin and Zillow, and I'll take the middle figure. Depending on the value of the house, some are $600,000 homes, and some are a couple million. Again, our property prices, just to give you a little bit of a scale, is still about half of what California would be. We compare ourselves to
Right.
California a lot because they're right next door. And so we look at value, we look at what's owed on the house, we look at the mortgage payment. A lot of times the mortgage payment lately is very good, very low compared to renting a new house, or our apartments have decided we're going to rip people off. We're going to raise our rents just extraordinarily. And so we look at all that. And these people have kind of checked, it seems like, before they come to me, or ask them if they have a realtor friend. I have a realtor I use. I have a mortgage broker I use. I have an appraiser I use. So if we have to, we bring in those people. So again, it's a financial decision more than an emotional. But when I deal with um, women want to keep the house. They are just comfortable there. They don't want to move. Once in a while, they'll say, I don't want to be here anymore, or he can afford it. So I have to talk to them sometimes and say, look, you don't want to be house poor. This house does have a high mortgage, or if the mortgage is reasonable, but you've got a pool, you've got a lot of land. What's if it's 2-story in Las Vegas? You got 2 air conditioning units. that are running all day from May through September. So we started in March this year. We had 104 degrees for a week. Our temperatures have gone. I've been turning the air on and off since March. So I try to explain the utilities could be high. All the heat goes up if you have a 2-story home. So sometimes we do decide, though, it's not a good time to sell, and someone's going to stay in there and make the payment, or they're going to split the payment. We'll appraise it later. I have let's look ahead. We'll remediate this issue in a year. Again, you go to court and fight about a house, the judge says sell. They don't care. And
Always.
they offer
Yeah.
that the one spouse can
Easy.
buy the other one out, but they
Yeah.
really don't care about the finances, what's going on in Vegas, which is sad. They really should. I mean, I shouldn't say all of them don't do that. I make them do that sometimes when I take it to court and explain to the judge why we don't want to sell, but they don't know what else to do. There's 3 options. Husband buys wife out, wife buys husband out, or you sell. But I come up with in mediation, no, let's share the house, or let's keep somebody in there for a year. Let's split the mortgages if we can, or have him pay the bills in lieu of alimony. And hopefully she's got some kind of job. So again, case by case.
Super, super helpful. I know it can be a very stressful point. Let's talk about spousal support. And this is something that makes everyone's blood pressure go up, especially because child support makes a lot of sense. Spousal support, in some cases, people will argue it's completely unnecessary. It's very historic. If someone has a skill and or an education, they can go get a job. And I think, at least here in Georgia, it's not as easily granted as it used to be. So I'm kind of curious, what are some creative solutions for spousal support? So this obviously is before you go to court. And if you go to court, it's a risk. You may or may not get it. Can you talk a little bit about that?
In Nevada, if you've got somewhat of a lengthy marriage and there is no magic year, I have seen years ago a young couple that were 20 got divorced, and he had to pay her a couple of years of either spousal support or alimony. We use the same word because he was a construction worker, and construction workers, when this Las Vegas was booming, which it still is again with the building, he was making money. She was working at McDonald's, and they were 20. So he had to pay her about a year and a half of alimony. So it's kind of strange to say it all happens in a lengthy marriage, but it's mostly the length. Nevada has no percentage formula or calculation for alimony. I actually like that because, again, it's case by case. It's really hard to plug in 2 people's incomes or one person's income and figure out their expenses and say, boom, you pay this. It never matches. I make them fill out a whole financial disclosure form with their budgets. Judges do too. If you go to court, we look at who's taking what debt, who's paying the mortgage, is the house selling where somebody's going to have some money, is the wife, husband both working, got a lot of stay-at-home dads, out of work dads. So again, case by case, we look at their ages, we look at their health, we look at their education, and then sometimes to avoid alimony, let's say both are working, maybe one makes more than the other, then we might start looking at some of the assets. Or if the house is going to be sold, I sometimes tell the wife, you've got a decent income, but I know he makes twice or 3 times as much as you, and your lifestyle is going to change. Let's ask for a bigger share of the house equity for the net proceeds, more than half. Let's ask for a little bit from him. I just settled a case like that. They paid extra. So a lot of unique ways to do this.
So let's talk about child support, which is mostly formulaic. How does that typically get handled in mediation?
Yes, we do child support first because that figure is going to be on the husband's side as an expense. It's going to lower his net income. In Nevada, child support is based on, let's say you have a joint physical custody arrangement, which doesn't have to be 50-50, as long as somebody has 40% of the time, which is 3 full days and 3 overnights a week, or it ends up being that way by the end of the month. Some people do this 2-5-5-2 schedule, where they have 2 days 1 week and 5 the next. So at the end of the month, let's say it's equal or 40-60-40. We look at their gross monthly incomes, and there's a calculation. I even have it on my computer, and we spit it out. Of course, we could change that. We could sometimes I have somebody who offers more or less, and then the person receiving the child support puts it on their financial disclosure form is additional income. So not income that's taxed, but income for purposes of the divorce case, because alimony is based on the payer's net. So he starts with gross, his tax deductions from the paycheck, and then his living expenses plus the child support he's paying. And that's how we look to see, hopefully the payor is going to be in the black and the one who needs it is in the red. But yes, child support, I don't know a case where I've not had child support at all. As long as the children are under, even if you're 18, if you're still, I got a bunch of seniors right now that they're 18 already. It's till you get out of high school. No law here for college education. Once they're an adult, court says we lose jurisdiction. But some parents agree to college tuition. I ask them if they want to do that, and I put it in the parenting plan.
Okay, so it's important to note that that can be done. So let me ask you one question on that. Let's say, because college could be anywhere from $5,000 a year to $100,000 a year.
Yeah.
Is there a way to put in some sort of flexible language where there's a look back? Let's say you have a 4-year-old and a 6-year-old, where when the first one becomes 18, there's a look back at your assets and your income. And if it's above a certain amount, this is how much you can pay. Like, what can you do to manage the risk and the upside?
Unfortunately, that's one issue that most parents don't agree to. They just agree. They know that the court can't make an order in the future. The one who makes more money always seems to find that out. And if they ask
Right.
me, I have to honestly tell them they're correct. So the cases that I've had where we mediate college tuition or the idea of it, again, I'm trying to get these people past the emotional stress of the breakup and get them divorced. And a lot of times those kind of issues, and you can do this in mediation, is we say, look, we both agree that we want to share college tuition, but our child's so young, we don't know if they're even going to college or what it's going to be. Some of them open a college account. They call them 529 college
Mhm.
accounts at a bank, and they agree who's going to put what percentage in there. So I do have a lot of parents doing that. But again, mediation is so unique. We can say, we'll look at it later. Or, yes, I know the court can't order it, but with the teenage children that's coming up, but they already know they're going, what can we do? Or are we selling the house? Could we take a portion of those net proceeds and put them into a college account? So again, very fluid, case by case, and you can agree to anything in mediation. So I listen to them, see what their concerns are, and try to come up with these ideas.
Retirement and investments. I know this is an area you and I were chatting about a couple days ago. A dollar of retirement isn't necessarily equal to a dollar of an investment. Can you kind of talk about
Yeah.
how there's trade-offs between retirements and investments? And even sometimes that has to do with the house as well. It's kind of like you get the house, but I get part of your 401k and then part of your investment account. Things that we
Right. So
need to think about and be aware.
yeah, so I have them bring me recent statements, and we look to see what they have, what kind they are. I do insist that I ask them if they have a CPA, and I ask them to check into that. If we're selling the house, I ask them to check into the capital gains issue, because they're going to possibly have a capital gains tax. And if it's early in the year and we can't wait to get them divorced till the end of the year, I can put in the divorce decree that they're each going to file separate the following year and claim half or a portion. It doesn't always have to be half of the capital gains. But again, sometimes we balance that against, is a house selling? Let's pay the tax now. Try not to, I call it devaluing. I try not to take every IRA, every K, every pension and split it down the middle. Again, that's what a judge might do, which is
Right.
absolutely crazy. I have learned from financial planners. And sometimes I bring in a financial planner, or I have them go meet another neutral and decide what's best for them and what's their lifestyle going to look like and who's getting what money and is someone getting child support and alimony. It's all tied together. But yeah, you're right. There's different values. Certain Roth IRAs are not the same as a regular IRA or 401k or PERS. We have a lot of public employment retirement system, they call it PERS. Police officers have PERS, firemen have PERS, school teachers have PERS. I actually use another law firm that has a side business to prepare what they call Quadro, QDRO, stands for Qualified Domestic Relations Order. And most pensions, not IRAs, need a quadro to the company that tells, they don't want to see your whole divorce decree. They want to see this special order about who's getting what. And these attorneys specialize in this. And I actually talk to them from the beginning. I actually show them the language of my divorce decree to make sure we're all on board, try to explain it to the client, and then have the client talk to the quadro attorney. So that's a difficult area, but a lot of people have that here. It's good that our companies provide that. And I've done this too to equalize if there was quite a few. I've given an entire IRA that belonged to the husband to the wife if she didn't need either as partial alimony or instead of alimony. So again, trading assets to accomplish the goal of how do we divide all this and what's best for each person financially.
Right. And I just want to reiterate, it's worth spending the money on expert, a certified divorce financial analyst or a CPA, because you really need to understand the tax consequences and the differences. So for example, a Roth IRA, the taxes have already been paid and gets to grow tax free. Whereas a regular IRA, that's not the same. So you're not trading dollars for dollars. So that's just super important. Let's move to mediation in high conflict situations. Do you think that mediation can be effective with a high conflict couple? And if it can work in those places and there's real hostility between the parties, how's it typically done to make sure that it can be successful or at least improve the odds?
You know what? That's the part I explained I deal with from the very beginning. Those first phone calls, one each to each party, I try to find out what is going on. I usually do ask both parties, is the other spouse, there been domestic violence? Because we have it both ways. Obviously, Las Vegas, unfortunately, is a number one city for domestic violence and deaths from it. People are killing each
Right.
other that used to date or married. It's horrible. And then I do ask about drug use and alcoholism. I deal with a lot of bipolar issues and people because that's going to affect how we're going to understand things, how we're going to speak, how we're going to meet. So I look for things that might make mediation a little harder. I never really give up on doing a mediation, but I talk to both people, both parties, and I learn what is the focus. A lot of times I'll have a spouse tell me that the other spouse is angry, controlling, narcissistic. Oh, I don't think they'll mediate, but you're welcome to call them and find out. And then I call the other side and they're seem normal and nice and they don't want to spend the money on two attorneys and two retainers and they absolutely want to sit down and work this out. And I think they feel better that I'm the barrier, that I'll be there, that they
Right.
won't be alone with their spouse. And I tell them they can't act badly in my office. It's a professional law firm. We have a whole section that does trust and estate planning. And I have my own department and we have a couple conference rooms in my office. And this is how you have to, I give them rules and I just listen. I judge people well. I've taken a lot of psychology, sociology. I find this very interesting. I've never been bored a day in 40 years. I've been stressed, frustrated, angry, but not bored. And yeah, so I just look for little warning signs, but it's interesting when I talk to both sides and sort of talk them down and explain to them we can litigate, we can do collaborative divorce or amicable divorce where you each have your attorney. Just recently had a couple choose that actually, and it's working out great. Amicable, you each get an attorney, but the four of you sit and collaborate amicably, mediate, and we're working something out. It's a very high asset case, no minor children, and so far so good. So we just try to figure out what's best for them and their personalities.
I spend a fair amount of time with some of my clients who are going through divorce doing pre-mediation coaching. And it's something I'm so passionate about because it really helps prepare them for mediation. It's number one about getting clear on their priorities, identifying their triggers. We practice staying regulated when the other side says something that pushes their buttons so that on that day, they're ready to go. And I also think it's important that other people know they can bring others into the mediation room. You can bring a financial neutral to handle the numbers objectively if you don't understand something. You can bring in a child specialist to represent the children's interests. I participated in many mediations to make sure that the person I'm working with is staying grounded and to be a thought partner. So it's okay to assemble a team. It's not always done that way, but it really depends on what your needs are. Can you talk a little bit about situations where mediation is not appropriate? When do you tell someone that mediation is not the right path? And I know you already mentioned active domestic violence or safety concerns. Are there other areas such as, power imbalances, et cetera, that mediation just cannot easily be successful in?
I think when people have a position from day one, and even though I talk to them about not sticking to a position because let's hear what the other side has to say. Let's meet and see what I have to say after I've learned their case. Sometimes I find that they they hide it from me and they're still grounded in whatever their position is. It's a lot of times it is the alimony issue. I mean, in the about 28 of my 40 years I've been mediating, I've had 1, 2, probably 4 failures. 3 were when the attorneys came, and that's a whole nother story, and 1 was just me and the couple, and she just no matter what I was gonna come up with, no matter what I was going to tell her that I think the judge would give her for alimony, she wanted to go to court. Or I can have the person who's supposed to pay the alimony deep down have this attitude that I'm not paying. I don't care. I'll go listen. I'll pay it only if a judge orders me to pay it. So sometimes those kind of cases, uh, a lot of times it's the mom saying, I don't want to do joint physical custody. I don't care what the law is or the presumption. I think I've got enough factors to say he's not a good dad, and I'm going to get my time. And I keep telling him, unless he's in jail, dead, a mental case, addicted to drugs and alcohol, or is beating the child, he's going to get a fair amount of time. It's pretty liberal and fair in Las Vegas. So those are sometimes what I've encountered as either ending mediation or we didn't start because I knew that they were just too grounded in their positions and they needed to go speak to an attorney and maybe they need to go to the first hearing and get the judge's attitude and then they might be back. I've had that happen.
So, can you talk a little bit about? I know here in Georgia, you can go for what's called a late stage case evaluation, where you bring your case in front of what's often a former judge or an attorney just to get a idea of where things go. Is that something that you ever work with your clients on?
Yeah, we have a senior judge settlement program, and senior not necessarily meaning they're 80 years old. It just means that I have a friend who retired at 56. She just didn't want to be a judge anymore. And
Sure.
so she's doing mediation, but she also joined the senior settlement judge program. So you have to write the judge a little brief and then the couple I do this mostly on my litigation cases. I actually have one coming up where we sit with the judge. And even though they can't make orders because they're almost like a mediator, they could say they separate us at one point. Then we can a little bit freer to say what we want. And they can tell the client, if I was a judge on your case, or here's the law. So there's somebody else saying the same thing that I might have been saying. And yes, it helps. I would say 80% of the time that helps. We settle with that assistance. You can also bring in when I do amicable or collaborative divorce, because I'm the attorney, possibly, you can bring in a mediator if the 4 of you are just getting nowhere. So
Right.
there's lots of tools. If people look at mediation and these different ways of even having counsel that are called collaborative and amicable, they're going to learn to work with a divorce coach like you and a financial person if they need one, and possibly a CPA. And again, I always say that knowledge is power. Get the knowledge so that you have the power to make good decisions or at least defend your position when you're in a mediation or even an arbitration. Probably emphatically state no to something, or I am never going to agree to that. or I'm not going to agree to that, or get up. I always tell them, if you need a break and you want to mull something over, let me know. But those kind of negative words, I'd rather them tell me that separately on the phone
Right.
before I get them together, or their attorneys if they're coming with attorneys.
Great. How can people prepare emotionally before a mediation?
Well, talk to someone like you. Um, if they're in therapy already, I tell them to talk to their therapist. I sometimes suggest, if I see their trigger point is custody or alimony or maybe the sale of the house, I discuss it a little bit more with them, try to calm them down, make them understand I am not a judge, I am not making a decision. We were just gonna sit in my office and discuss this. And I'm gonna listen to you, and I'm gonna listen to him and not him or her, and I'm going to try to come up with ideas. And I'm not gonna let anybody, like I said, get one up on the other.
How do you help someone who walks in and says, I just want this to be fair?
So I explain that that's the whole idea of mediation, or an agreed upon, however you get to it, agreed upon divorce decree or parenting plan is i- it's got to be something both of them feel comfortable with, feel that they were heard, feel that they were seen, feel that their children are going to be okay, that nobody's going to be on the street or filing bankruptcy. Although sometimes we've agreed, let's go file a joint bankruptcy because somebody had a medical issue. So I'm not like the attorneys that litigate that say, you've done a good job when we all leave the courtroom and no one's happy. Nah,
Right.
I'm the glass is half full. I want both people to be somewhat happy, that the judge even heard them and listened and came up with something fair.
How do we keep children from becoming bargaining chips in mediation?
Well, here, the judges are pretty strict about this, and so am I. You don't talk to the children, you don't send messages through them. They are not little messengers. You're careful not to, you want to badmouth your spouse, wait till the kid's with him and talk to your girlfriends and your mom or your boyfriends or your new girlfriend or boyfriend all you want. I had a case where the poor kid that was a teenager heard the neighbors talking outside his window. He was upstairs in his bedroom, that the mom had cheated on the dad, and he didn't know that. And then he never
Yeah.
wanted to see his mom again. And we were in court and we were in therapy and we were reunification. It was horrible. So these people need to know your child's not your friend. They're not here to listen to your woes and emotions about your divorce or the other parent. And you don't want a child growing up hating either parent. I'm big on therapy. I want
Mhm.
kids in therapy or reunification therapy, because otherwise they're going to have issues in their marriages or maybe never get married.
So I really want our listeners to hear this clearly. Children don't need perfect parents. They need parents who stop turning every decision into a battlefield. That is one of the things I say most often on this podcast. And it's one of the things I believe most deeply. Your
Yeah.
children are watching always. They're watching how you handle conflict. They're watching whether you can put their needs above your ego, and the choices you make during this process that are going to shape how your children handle conflict in their own lives and in their own relationships. All right. So I want to give our listeners something they can take with them. If you're getting ready for mediation, here's your checklist. Number one, know your priorities. Write down the three things that matter most to you and rank them. Everything else is negotiable. Number two, understand the difference between positions and interests. Know what you want, and more importantly, know why you want it. Number three, get financially educated. If you don't understand your family's finances, fix that before you walk into the room. Work with a CDFA or a financial planner. Number four, work with a coach or therapist to separate your emotions from your strategy. You can feel everything you need to feel. Just don't let your feelings make your decisions. Number five, prepare your documents, financial statements, tax records, asset lists, debt summaries, parenting schedules, school information. Bring everything organized and complete. Number six, come with an open mind. The best mediation outcomes come from people who are willing to hear a solution they didn't expect. Number seven, have your own attorney review an agreement before you sign it. This is an optional. Number eight, remember the goal. The goal is not to win the divorce. The goal is to build a living, sustainable future for you and your children. Rebecca, did I miss any other key points?
No, that sums it up. I think one thing you said that I wanted to touch on is that I tell these clients that you are my partners. We are going to do this together. You're going to have homework. Like you said, get your documents in order. I want statements on all accounts, information, value of house, and it's going to be like a puzzle that's on the dining room table, and we're going to try to fit the pieces where they make sense and where they fit with your help. I'm just steering the ship, but you're deciding where we go. And the idea is to have a say of your life, your family, your assets, and not let some judge that's having a bad day or doesn't have the time to listen make a decision for you that you're stuck with. I've seen some judges ruin people's lives, and I couldn't even file a motion for reconsideration because I knew that judge wasn't going to change his mind. And here we
Yeah.
are. So they love that. They love to hear that, oh wow, I'm a partner. I'm part of it and I get to have a say and be heard. So that's the best part of it.
Thank you for that wisdom. I
You're
want to add
welcome.
one final thought for our listeners. Mediation is really a strategy and a process that gives you flexibility. It gives you the opportunity to be the architect of your own future instead of handling the blueprints to a stranger in a black robe. The best arguments are not just legally sound, they're sustainable in real life. They work on a Tuesday morning and on a Saturday night. They work when the kids are sick and when someone gets a new job and when the holidays come around again. And that's what we're building here, not just a divorce settlement, but a life and the ability to move forward. Rebecca, thank you so much for joining me today. Your experience, your wisdom, and your genuine care for the families you serve came through in every single answer. Listeners, if you're in Las Vegas and you need a family law attorney who understands mediation, collaborative, amicable divorce, and doing the right thing the right way, look up Rebecca Miller at Cooper Coons. Rebecca, thank you again so much.
Oh, thank you, Justin. This was very, very educational for me also. Working with divorce coaches, it needs to happen more here. And yeah, thank you for letting me share.
Super appreciative. And here's what I want you to take away from today. You have more options than you think. Divorce does not have to be a war. And the best outcomes come from people who are willing to think creatively, get the right team around them, and stay focused on the future instead of being stuck on the past. If today's episode resonated with you, here's what I'm asking. Subscribe to the show wherever you listen. Share this episode with one person who needs to hear it, and visit www.reclaimandreboot.me to learn more about how I help people navigate divorce consciously, strategically, and with dignity. My book, U 2.0 Divorce A Better Way Forward, is available on Amazon.com. And I have a new co parenting playbook also available on Amazon. And if you're going through your own divorce and you want someone in your corner who will help you think clearly, make better decisions, and build the life you're proud of, that's exactly what I do at Reclaim and Reboot. Remember, divorce does not have to define you. It can be the beginning of something better. This is the Conscious Divorce Podcast. I'm Justin Milrad, and I'll see you next time. But before we go, I forgot to ask Rebecca, how do people get a hold of you?
The best way is email. It's Rebecca, Rebecca, at coopercoons.com. And that's the name of the firm, COOPERCOON as in Nancy, S as in Sam.com. Phone number is 702-998-1500.
Outstanding. Thank you, everyone.